In the current political climate, hysteria and myopia dominate the discourse, obscuring the subtleties of complex legal rulings. The Supreme Court's decision in Trump v. United States has elicited reactions that are either hysterical or woefully short-sighted, necessitating a closer examination of the intellectual decay that has taken root. From the left, there is a cacophony of alarm. The ruling, which carefully delineates the boundaries of presidential immunity, is twisted into a harbinger of tyranny. Headlines scream about dictatorial powers and the collapse of democratic norms, as if the Supreme Court had suddenly bestowed upon Trump the divine right of kings. This hysteria is not only misplaced, but also dangerously misleading. The court's decision clarifies that while certain presidential duties are shielded to ensure the effective functioning of the executive branch, personal misconduct remains firmly within the reach of the law. Yet, to listen to liberal commentators, one would think the very foundations of the republic are crumbling. This unrelenting hysteria fails to appreciate the checks and balances that the ruling maintains. It is an exercise in fear-mongering that only serves to undermine public understanding and trust in the judiciary. The liberal reaction, far from being a measured critique, descends into absurdity, where every legal protection is twisted into a prelude to despotism. On the conservative side, there is a stunning lack of foresight. Their jubilant celebration of the ruling as a sweeping victory for Trump is not only premature, but also fundamentally ignorant of the legal realities. The conservative media, in its infinite wisdom, interprets the decision as an absolute shield, a get-out-of-jail-free card for the former president. This interpretation is as myopic as it is misguided. The decision explicitly remands the case to lower courts to distinguish between Trump's official and unofficial acts. While his communications with the Department of Justice were deemed official and thus enjoy some degree of immunity, many other alleged misconducts, especially those outside the purview of official duties, remain prosecutable. The conservative narrative conveniently overlooks this crucial point, preferring instead to bask in a false sense of triumph. Their glee is particularly insidious, rooted in the hope that Trump, a convicted felon, might one day be able to pardon himself if he regains the presidency. This grotesque celebration reveals a disturbing willingness to undermine the rule of law for partisan gain. Consider, for instance, the infamous Georgia call, where Trump allegedly sought to influence the outcome of the election. Even if we were to strip away all other allegations, his actions in this instance, and many others, fall squarely outside the realm of protected official acts. The reality is that Trump is likely to face immediate prosecution for these unofficial actions once the case returns to the lower courts. The conservative celebration is not only misplaced, but also indicative of a profound inability to see beyond the immediate propaganda victory. But let us not rush to extol the virtues of this ruling either. While it may seem balanced on the surface, it reeks of judicial cowardice. The Supreme Court, rather than making a definitive ruling on the extent of presidential immunity, has punted the responsibility to the lower courts. This decision is less about justice and more about the justices washing their hands of a politically volatile case. By remanding the case, they hope the lower courts will bear the burden of disqualifying Trump, sparing the Supreme Court the backlash of a direct ruling. This reluctance to decisively address the issues at hand is a dereliction of duty. The court should have the courage to make clear rulings on matters of profound constitutional importance. Instead, they opt for a cautious, cowardly approach that leaves the nation in legal limbo. The justices' decision to remand critical aspects of the case back to lower courts is a transparent attempt to avoid the political heat. This is not the fortitude we expect from the highest court in the land. It is the behavior of bureaucrats passing the buck. The Supreme Court's decision is neither a harbinger of dictatorship nor a sweeping absolution. It is a judicial maneuver designed to shift the burden onto the lower courts, ensuring that Trump's downfall is handled at a level where the justices can wash their hands of the fallout. The hysteria and short-sightedness that dominate the discourse are not only intellectually bankrupt, but also corrosive to the fabric of our democracy. Let us hope, perhaps in vain, for a return to reasoned debate and thoughtful analysis, where legal rulings are understood in their full complexity and not reduced to fodder for partisan theatrics. Thus, with the judiciary's deliberate punt, the hot potato of Trump's downfall lands squarely in the lap of the lower courts, ensuring the inevitable dismantling of his bluster and bravado as the scales of justice tip irrevocably against him.